Thank you. Now we're live. Thank you, Senator Hatchett. First bill on the agenda is House Bill 56. Representative Cantrell was just outside the door. Somebody mind hollering for him? Hollering. We do have a judge visiting us today, Judge Clint Bearden from the Northern Circuit. Good to see you, Judge. Thanks for being with us. Now in the Senate, we at least tuck our shirts in. Coming in sloppy and.
Yeah, a little sloppy.
Yeah. So we're working off LC 441993S. That was not the original sub that was on your agenda, but I believe there's only one change, and that's the effective date. Is that right, Representative?
That is accurate, Mr. Chairman.
All right. Tell us about House Bill 56.
All right, House Bill 56 provides for an additional Superior Court judge position in the Blue Ridge Circuit. Judicial Council ranks our circuit as the second highest circuit of need in the state. Our judges a couple of years ago were operating at a caseload of 1.5, and that was 2 years ago. And I've got the data in the supplemental material that shows that that's only increased by 10% each of the following years, so it's even higher than that now. I'm not running for re-election, but somebody from my county will be coming back to you for another judgeship real soon, because Cherokee County, as you know, is growing very fast. This bill was supported unanimously in the Judiciary Committee in the House and also on the floor of the House. So I'm happy to get into more detail if you want it, but that's the bill.
All right. Any questions for Representative Cantrell? Question from Senator Cowser.
Thank you, Mr. Chairman. I'm just curious. I mean, this year it seems like more than usual we're getting additional judgeships. That you're about the second, third, or fourth different area, and I never see them go away.
Right.
You know, we're losing population in South Georgia, but we don't lose judges there. We're having more and more Superior Court judges, and I just don't know if that's commensurate with population growth statewide, or, you know, is there any coordination as to how many? I mean, obviously the judge is going to ask for more judgeships every year. That makes their job easier the more of them there are.
Right. Senator, I hear you. And I had to delve into this and really learn how it worked and how the process works. And there's the Judicial Council of Georgia looks at they have kind of a criteria that they've developed to determine which circuits have need and which don't. And I think before it's triggered, the judges have to be working at least a 1.2 load, and then traditionally 2 of those have been approved each year. Now last year they didn't approve any, or was it the year before? Because of the year before, because of the budget cuts, and so that led to a little bit of a backlog. So maybe that's what's more in your mind, is there have been a few more to make up for time lost a couple years ago.
Well, you don't have a hard time ever finding a Judiciary Committee that votes against it, because the judges are our friends.
That's good to know.
We're happy to help them. But I'm always curious what never goes backwards, or how we decide. Because there was also something in the budget this year about adding on days for emeritus judges to help them out, and it seems like they're getting an awful lot of help this year.
Well, you make a great point. It does seem like the Judicial Council should consider districts that are operating in the reverse direction as well, from a population and caseload standpoint.
Thank you.
And to clarify on that, there's I think everybody's folder, a letter from Judicial Council of Georgia, and it outlines the top 8 circuits that met their criteria for a new judgeship. And I believe numbers 1 through 3 are in the current draft of the budget, but I think 4 is one we passed at this committee as well. And so I think there may be 4 total this year, 3 that so far look to have funding in the budget. But Senator Kirkpatrick.
Mr. Chair, at the appropriate time, I'd like to make a motion to pass.
All right, let's make sure. Any other questions from the committee? Representative Cantrell. All right, recognize Senator Kirkpatrick. The motion do pass by committee substitute. Is there a second? Second by Senator Hatchett. Any discussion? All those in favor of the motion, please raise your hand. It is unanimous.
Thank you, Mr. Chair. I heard it was a
it.
lot more difficult in this committee than that.
We'll come back again sometime.
I think this will be my last time.
Yeah. All right, let's move down to House Bill 1346. Chairman Ballinger.
Thank you, Mr. Chairman.
We're working off a substitute which is LC 441980S. Good afternoon.
Hello, Mr. Chairman. How are you doing?
I'm good. About you?
I'm doing very well, thank you.
Good. Take your time. We're
I
fine.
do apologize.
I think I called upon you as soon as you walked in the room.
One of those days where you're always a day running just a few minutes late. Appreciate the indulgence of the committee and the committee chair.
Yes.
House Bill 1346 is a relatively short, concise bill. Right now, there is prohibition against our clerks of court from serving as lawyers. Obviously, we want those clerks to be impartial and not take sides in the matters because they have a very important job of keeping the files and keeping all the filings for various cases. This would allow our clerks of court to, or assistant clerks of court, to serve as judge advocate generals in the military.
All right. Any questions for Chairman Ballinger? Man. All right. No one signed up to speak on the bill. What's the pleasure? Am I right on that? What's the pleasure of the committee?
I'd like to make a motion to pass.
Sen-
House Bill 1346.
Motion do pass by committee substitute by Senator Hatchett. Do we have a second? Second by Senator Parent. Any discussion? All those in favor of the motion, please raise your hand. It is also unanimous, and I forgot to ask, because it's the first time we've done this year, Representative Cantrell, but who's going to carry the bill in the Senate?
Senator Kirkpatrick.
All right,
has
Senator
agreed
Kirkpatrick.
to
Thank you.
carry the bill. Thank you, Mr. Chairman, members of the committee. I appreciate your support.
Thank you. And we have a note that Senator Thompson's going to carry House Bill 56. If he's not, he will now. All right. Last bill on the agenda, House Bill 1274. I have a different substitute than was on the agenda for this one as well. And just because the author wrote on the copy, and so we printed another version, but it's exactly the same. We're working off of LC 490947S. Did you write on this copy as well, or is it clean?
It's clean.
Okay, good.
It's clean. I won't write anything on that one, Mr. Chairman, I promise.
All right, Representative Carson,
Am I on?
you are on.
Great. I appreciate the committee's indulgence. I'm working off of, as the chair said, LC 490947S. House Bill 1274 was a bipartisan measure. What this is doing is codifying in Georgia State Code the first time a definition for anti-Semitism. What this does, it codifies the International Holocaust Remembrance Alliance, IHRA, working definition of anti-Semitism. This definition is the consensus international standard because it can be utilized to objectively assess all ideological forms of anti-Semitism. This definition is used by the U.S. Department of Education and Justice and for U.S. Department of State. It's also been adopted by the EU, 34 countries of the IHRA that are members, and about 24 other countries as well. You might be asking, what is that definition? Well, you should have a printout in your information, and it's at the bottom of the first page, committee members. And I'll just read it to you. Anti-Semitism is a certain perception of Jews which may be expressed as hatred toward Jews. Rhetorical and physical manifestations of anti-Semitism are directed toward Jewish or non-Jewish individuals and their property, toward Jewish community, institutions, and religious facilities. We're also working on a substitute because as compared to the House version, Mr. Chairman, we have added language specific in lines 43 and 44 of the bill, lines 43 and 44, to basically to specifically state that the working definition of anti-Semitism as adopted from the International Holocaust Remembrance Alliance, lines 43 and 44 include the examples of anti-Semitism set forth therein. And those examples start on that second page that I provided. I did want to mention one other thing that came up in House Judiciary, as well as some other floor debate. This has no bearing whatsoever on freedom of speech. If you take a look at lines 51 through 54 of the committee substitute, nothing in this code section shall be construed to diminish or infringe upon any right protected under the First Amendment to the U.S. Constitution or the Georgia Constitution, and shall not be construed to conflict with local, federal, or state discrimination laws. What we're doing for the first time here, with the support of our various groups from the Jewish faith, the Jewish community, is codifying a definition of anti-Semitism as a result, or as a test in regard to crimes and so forth, not free speech. So with that, I'm happy to go into more detail, but happy to take a question or two, Mr. Chairman.
All right, we have any questions in the committee? We do from Senator Parent.
Thank you, Mr. Chairman. Thank you, Representative. I have 3 questions, if that's okay, Mr. Chairman. So my first question is actually more of a procedural question. I'm not sure that I'm completely clear on the legal weight given to General Assembly findings that are not changing statute. And can you fill me in on what that does? Or I suppose someone else maybe on my committee or legislative council could. I've seen it several times, but since it's not actually part of the law, I'm curious is it just supposed to be, if a court were interpreting it, you would get to see intentions behind the actual weight of the law?
Legislative counsel.
The kind of the default position, Senator, is that if the plain meaning of the statute is clear, then a court would not reach the legislative intent or finding. So it would depend on its application or what the issue was before the court as to whether or not it would have any impact on the legal analysis of the statute.
Can I ask a follow-up on that? Is there anything in our code that specifically says that debate and arguments made in promulgation of statute are not to be considered by courts? I thought that we had something like that.
That may well be the case. It's not something I'm familiar with, but can check and report back.
I'd be
to you.
curious on that because I can see where this then would have about the same amount of weight. But okay, I appreciate that. So my second question is, and this is for you, Representative Carson.
Sure.
So since we are referencing a definition promulgated by or adopted by International Holocaust Remembrance Alliance, including examples of anti-Semitism set forth therein, is it your understanding that as that changes, our definition would likewise change?
No, ma'am, it would not, because what we're doing here is referring to a definition as of a certain date. If I may direct you to line 43, well, actually 42 and 43, in the working definition of anti-Semitism adopted by the IHRA on May 26, 2016. So we're locked into a definition as of a certain date, almost 5 years ago.
Okay, so any changes since May 26, 2016 or going forward would not change?
That's absolutely correct.
Okay, and I assume I understand the need for using this definition, and I guess it just saves paper to not actually put it in the statute?
What we wanted to do, and we did have this conversation, Senator Parent, on the House side. What we wanted to do is make sure that we in Georgia Code are deferring to an internationally recognized entity in regard to the definition, rather than even have the appearance, much less actually coming up with our own definition here in Georgia. In addition, what we did in the substitute was make sure to include that the examples included where therein, as referenced on lines 43 and 44 of the bill, it would be a lot. I mean, yes, we could mechanically, but what we want to do in Georgia is make sure to state, not only from a policy standpoint, we're defining anti-Semitism, but also from a policy standpoint, we're referring to an internationally recognized definition as opposed to anything that may appear to be a Georgia-based definition.
Okay, thank you. And then my final question is,
Yes, ma'am.
obviously we just did the hate crimes law. Was it last year?
2020, I
2020?
believe.
Did that include religion?
I believe it did.
Okay, so I'm just curious. I definitely, I see some need for discussion of anti-Semitism, frankly, but I just am curious why we would pick this, when we just did that bill
I
a year
understand.
ago that included religion.
I understand. With the chair's indulgence, I would defer to my colleague, Representative Walensky, the only Jewish member of the General Assembly, but if that's all right with the chairman, obviously.
You also signed to be heard on the bill, so if you want to be heard while you're up there.
Thank you. Thank you. Thank you. Thank you, Chair. Yes, I am in the minority. Not only am I a Democrat, but I'm the only Jewish person in the whole Georgia legislature.
But we love you.
And everybody loves me, so that's good. To answer that question, that's why this bill is so important, is Judaism is complex. It's not just a religion. It's a race, religion, and national origin. So Judaism is treated differently than any other thing we see in the hate crimes bill. And that's what's so complex and leads to complications and leads to how people use it. And that's why this bill is so important, because it expresses that, first of all, that Judaism is all three: race, religion, and national origin, and how this applies. And it puts guardrails on what is anti-Semitism, which I can speak to now if the chair is okay with. Okay. So I'll continue off that. Well, first of all, about this bill, why it's so important, and the confusion that this bill leads into. Oh, okay. Did that answer your question? Why it's so important?
Well,
how it
I was
applies
just
to the hate
talking to the
crimes?
chairman about something different,
Okay.
Representative Walensky, so please continue.
Yeah, and so, well, in dealing with, I'll talk about that, dealing with the hate crimes and why it's so important, how this will be applied. Well, first of all, as lines 44 and 45 of the bill says, and why it's so important is it's as evidence of discriminatory intent for any law or policy. So as we starting point, we know that none of our law or policies on our Georgia code are unconstitutional because they don't limit freedom of speech. So this is merely evidence of the intent for those laws and policy. So right away, and in a second, I'll explain to you the Supreme Court case that this removes this away from freedom of speech and doesn't limit speech because it's only describing the evidence or intent of any law or policy currently on the books. And how it's applied to the hate crimes, why it's so important is right now, when we have a situation where there is you first have to actually have physical harm, and then or you can have property damage over a certain amount, and then there's whether it's a hate crime of added sentence and how this is applied. Well, this is only looking at the evidence of that intent of what occurred. And that is why this is a important addition to the hate crimes, because it gets complicated, as I said, when you talk about Judaism on whether it's race, religion, or national origin, and this gives prosecutors the ability to apply it, but also this bill gives hypothetical situations to defend themselves to show that it's not anti-Semitism. And specifically, the Supreme Court case is Wisconsin versus Mitchell. That case asks whether enhanced penalties for racially motivated crimes violates a defendant's First Amendment rights. And it specifically found that the First Amendment does not prohibit evidentiary use of speech to prove motive or intent. And so that's all this bill does, and it's very clear that it's specifically looking at the intent, and therefore in no way violates freedom of speech, and is merely observing the conduct that occurred. And once again, that's why it's so important to me and many others, is it's putting guardrails on what anti-Semitism is.
All right. Any other questions from the committee for either representative? All right. Thank you. We have a few people that want to be.
I just wanted, if I could, Mr. Chairman, I just wanted to mention that the Federal Anti-Semitism Awareness Act, which included this codifying of this definition, passed the U.S. Senate in 2019 unanimously. It was Senate Resolution 852.
All right. All right. A few people signed to be heard on the bill.
Absolutely. Thank you, Mr. Chairman.
Yeah, thank you. If you'll sit tight. I may mess up pronouncing some of these names. Elise Cohen, concerned Jewish citizen. Good afternoon.
Good afternoon. Thank you, Mr. Chairman, and good afternoon to all of you. My name is Dr. Elise Cohen. I'm a Jewish Studies Middle East educator, a scholar activist and a writer, and a Jewish life cycle facilitator. My research has specifically been focused on experiences of Sephardic and Mizrahi Jews. That means Jews from the Middle East and North Africa and Israel, specifically around eviction, war, discrimination, and social movements. For almost 20 years, I led North Americans on delegations to both Israel and Palestine to meet with human rights defenders, scholars, activists, and communities to see for themselves what's happening in Palestine under Israeli occupation, as well as to understand what's happening inside the internationally recognized borders of the State of Israel. In addition to my years of research and leading delegations, I lived in Israel during high school, university, and another 2 years while working with Palestinians in the Palestinian and Jewish sectors in Israel on peace and coexistence during the Oslo Peace Accords. It is a bizarre thing as a Jewish person to be asking you to oppose an anti-Semitism bill, HB 1274. However, this bill is attempting to codify a working definition of anti-Semitism that is supposed to be used as a tool to discern what is anti-Semitism, not as a concretized definition that could create harm even to other Jewish people. The International Holocaust Remembrance Alliance working definition of anti-Semitism includes several examples that tie Jewish identity with the State of Israel. Self-determination of Jewish people to the State of Israel, which as a Jewish person forces me to have Jewish self-determination defined for me in Georgia law. It also forces a loyalty to a country, while also specifically singling out Israel as the state to be treated differently than any other state. To me, the bill itself is an example of anti-Semitism rather than a fight against it. Additionally, though the language says that double standards should not be applied to Israel as part of a bill on anti-Semitism, the bill is doing exactly that, singling out Israel from all other nations, codifying that we as U.S. citizens do not have the right to be critical of Israel in the ways we'd be critical of any other nation, including our own. In fact, in mentioning Israel as a democratic nation, in that same sentence, the bill does not once mention that anti-Semitism does not include being critical and working against the 55-year Israeli military occupation of Palestine, which is anti-democratic and is labeled as an apartheid system for human rights organizations, including Human Rights Watch and Amnesty. Take this example. There is no reason for the state of Georgia to protect one country over another 195 countries in the world. Imagine if a similar bill attempted to silence debate about China's human rights records, about the occupation of Tibet, the horrific treatment of the Uyghur Muslims, by providing a legal basis to claim that such criticism against China would be motivated by anti-Chinese racism and therefore constitutes a hate crime. We have bills that protect Jewish people and protect most of us who are minorities in this country. We don't need a specific one to single out Jewish people, tying it to the State of Israel, or also silencing us and our rights to speak freely. In the vast literature we shared with all of you, besides the Jewish Georgians opposing HB 1274 in a letter published in the AJC, fact sheets from the ACLU, CARE Georgia, and Project South, an article from one of the drafters of the bill, Kenneth Stern, who said that the IRA definition should not be codified because of the way it already chills freedom of speech. A host of Jewish organizations that have said they oppose its adoption, including a progressive pro-Israel network, including J Street, New Israel Fund, and Americans for Peace Now. Holocaust, Middle East, and Jewish studies scholars in the Jerusalem Declaration on Anti-Semitism, along with legal experts, oppose the adoption of IRA for the same reasons. Independent Jewish Voices has 11 pages of examples of how the IRA definition has already been used to squelch free speech all over the country. I have it here if you would like to see it. All based on being critical of Israeli policies. Passing this bill will not only silence Palestinian advocates, it will also silence people like me as Jewish educators. It will silence a whole generation of young Jewish people who are in the life of our community, and Israeli colleagues and lawyers who are also opposed to it. This bill, like other bills that specifically target minority groups in our country, is not making it safe for us as Jewish people, but actually reinforces the separation of Jewish people from other groups that experience hatred and violence. Passing a bill that claims it is to combat anti-Semitism when it's actually to silence free speech is a dangerous act, and I urge you to oppose HB 1274. Thank you for your time and consideration.
All right, you have a question, Senator Parent?
Yeah. Thank you, Mr. Chairman. Thank you, Dr. Cohen. I thought, and I was just looking for it, but I thought there was something in there that says that criticism that would be leveled the same way it would against other actors would not be considered anti-Semitic.
And I guess my response to that is, how do we measure that when already this definition has been used across the country to target student organizations and to target academics and to target people who are actually speaking specifically about critiquing Israeli policies? So that's already happening. It's in this 11-page IRA definition at work. And what we know about this definition and how the IRA definition is working is that it is doing exactly what it says it won't do, which is targeting people in that way.
Okay, and you don't think that that situation could be helped by the First Amendment protections written into this particular code section?
I don't, and I am not a legal expert, but I will refer to the ACLU document that y'all should have gotten, and also for other legal experts that have talked about how this particular, I wish that, I know there's ACLU people in the room, so I feel a little inept to communicate the correct wording. Actually, wait, I have it. Hold on. One moment. Just want to say the pressure feels like it's on right now. I know it's in this document. I'm sorry. I'm trying very hard to find it under the pressure. Am I allowed to ask the ACLU people here to help find it?
David Goldman signed up to speak from the ACLU. Is that who you're referring to?
Yeah.
So he's going to be speaking a couple more down the
Great.
list. So.
But the ACLU document refers to it. I'm sorry that I can't find it under the pressure.
All right. We have a question from Senator Hatchett.
Thank you, Mr. Chairman. Obviously, it's surprising to have someone speak against the bill, but I was listening to your reasonings behind it and was wondering if, obviously I don't want to assume, but I assume you would be in favor of this type of policy where we would, strengthen the laws against anti-Semitism. Do you have suggestions about how you would like to see the bill changed to address your concerns, or are you speaking in opposition to the policy behind the bill?
I'm speaking the way the bill comes through and supporting the IRA definition as a whole. I'm against and opposed to, and it's for the reasons that I said here. I know this experience personally. I also have seen it and its impacts across the country and across the world. I work on global Jewish networks, and we've been talking about how it's really problematic and harming people in terms of free speech. So it is weird to be up here as a Jewish person saying I don't want this bill, but as I said, and as people have said before, that we are covered, Jewish people are covered under already existing laws. We do not want to be separated. The Jewish Georgians who are opposed to this do not want to be separated out as a different group and a different people, because what that does is sets us up for more targeting. So there's already laws in the books. What we would love is for people to actually protect us under those laws. And what we would also like, and I would like to see, is make sure that we're actually having conversations about anti-Semitism in a real level, and that we don't pass multiple laws about chilling free speech.
Thank you.
I am concerned. I didn't say it in the beginning. It says it in our in the Jewish Georgians opposing 1274 in the AJC article, that of course we're concerned about anti-Semitism. But my fear of this bill passing is way more than the kind of alliances I've already made as a Jewish person of people who I know who will stand up against anti-Semitism with the laws that we already have on the books, and that's more significant to me.
Thank you.
Sure.
All right, any other questions from the committee? All right, thank you, Ms. Cohen.
Thank you.
Next, we have Kareem El Hassini.
El Hassini.
Was I close? I fell apart at the end there. Good afternoon.
Good afternoon, thank you.
Yeah, thank you for being with us. And I have CAIR is the group
Yes,
that you're
CAIR,
with.
the Council on American Islamic Relations.
All right.
Good afternoon, committee. Chair Strickland. My name is Kareem El Husseini. I'm the Government Affairs Director with the Georgia chapter of CARE, the Council on American Islamic Relations. I'm here representing Georgia's Muslim communities. And I want to start off by saying anti-Semitism is real. It's a dangerous and insidious ideology. And it's great to see that Georgia legislators want to find ways to make our state safer for our Jewish friends. However, one community's safety should not come at the expense of another's. The definition of anti-Semitism provided by this bill wrongfully conflates criticism of a country, Israel, with anti-Semitic acts. If this bill were to pass, it would have an impact on more than 100 Georgia code sections and how criminal and civil laws dealing with discrimination are applied in this state. To give just one example, last week, this committee passed out SB 171. I was here testifying against it. It's a bill that criminalizes lawful protest and requires counties and municipalities to implement a permit system for any assembly on public property beyond all reason and promising harsh punishments for anyone who puts a toe out of line. I bring this up because HB 1274 and SB 171 intersect in targeting Palestinian rights activists. Palestinian rights activists who speak out against human rights violations of the Israeli government. For example, following the Pittsburgh Tree of Life shootings and bombings in Gaza, the Berkeley Students for Justice in Palestine and Jewish Voice for Peace chapters planned to hold a joint vigil to mourn together. And the event faced backlash, including a letter to the OCR, the Office of Civil Rights at the Department of Education, by attorney Joe Siegel, which claimed that the vigil would portray Israel as a racist nation, which he noted contravened the IRA definition of anti-Semitism. If HB 1274, not only are you creating enhanced penalties on First Amendment protected activities, but you're also creating an environment where municipalities and counties could refuse to issue permits out of fear of violating this bill. You're passing the liability down to the municipalities and the counties, thereby stifling First Amendment protected activity and in turn discriminating against a whole other group of people, Palestinian rights activists. And yes, Section C in the bill says that nothing in the bill shall infringe upon First Amendment rights. But who gets to decide whether something is or is not infringing on their First Amendment rights? And that's a judge. And by the time the issue gets to a judge, the harm has already been done. Someone's been charged, prosecuted, put in jail, has gone through the trauma of being put through a system while a judge decides. Someone who has asked for a permit to protest Israel's human rights violation has already been denied their permit. We know this bill is unconstitutional, and now you do too. If this bill is if this bill passes and is enforced, there will be lawsuits against the bill. And just like there are lawsuits against existing Georgia law that prohibit people from boycotting Israel if they want to contract with the state, and a judge will find in our favor, just like a federal judge found in our favor on the anti-boycott law, which prompted this body to change the financial threshold in that law from 1,000 to 100,000 just this year. If this bill passes, it will put a strain on the already beleaguered judicial system, and the state will expend resources that it could use elsewhere to fight these lawsuits. And all of that while it's not actually cracking down on anti-Semitism. In the United States, criticizing your government is not only protected First Amendment activity, but it's also considered patriotic. I want to repeat that. In a democracy, it's patriotic to criticize your government, and if you can't do that, then you don't live in a democracy. Yet under this bill, with this new definition of anti-Semitism, we're not allowed to criticize the practices of a foreign government. This bill ultimately undermines our civil liberties, and it fails to address real bigotry. And whether you agree with my testimony today or not, I'm asking you to not restrict my First Amendment rights by passing this bill. Thank you.
All right, any questions from the committee? All right, thank you. Next, we have Gary Flack speaking on behalf of himself. Good afternoon.
Good afternoon. I sort of didn't know what to put down as to who I represent. I'm a longtime citizen of Georgia. I'm Jewish. I'm an attorney, and I read the newspaper. And based on that, I have concerns about this statute. Bill, it's not a statute yet. For more than 70 years, since Israel became a country, Jews and Palestinians have disagreed about control of that portion of the Middle East between the Jordan River and the Mediterranean Sea. Our Georgia legislature does not need to get involved in this dispute. The IHRA definition of anti-Semitism, which House Bill 1274 adopts, oversimplifies the political problems in Israel and Palestine, and it over-sanctifies the state of Israel. The definition gives several illustrative examples of anti-Semitism, and I'm going to focus on just one. If I understood the remarks here earlier, these are no longer illustrative examples, but they're part of the definition by the bill that's before you. The one I want to focus on says the following as an example of anti-Semitism. Denying the Jewish people their right to self-determination, for example, by claiming that the existence of a state of Israel is a racist endeavor, is anti-Semitism. There are many mainstream Israeli groups that regard this right of self-determination to be racist because it doesn't take into account the other people living in Israel and in the West Bank. But regardless, people should be able to discuss self-determination without being defined as an anti-Semite, and it's their right to call people racist if there's any basis for that. More broadly, criticism of Israel is not necessarily anti-Semitic. Such criticism is not the same as hatred or a violent threat against an individual or a group of people, which is what's commonly understood as anti-Semitism. Georgian Jews are protected by the Georgia statutes and also the Federal Civil Rights Act of 1964. We don't need a new law that chills our right to free speech. And I suggest we go with the ACLU, and I encourage you to reject this bill. Thank you.
All right, thank you, Mr. Flack. Any questions from the committee? Thank you for joining us today and sharing your thoughts on this. Last person on the list is David Goldman, ACLU of Georgia. Good afternoon. Go ahead.
Great. Good afternoon, Chairman and members of the committee. My name is David Goldman, and I am the Policy Counsel for the American Civil Liberties Union of Georgia. Throughout the years, the ACLU is known as a champion for free speech. This is a space that we've been in, and people rely on our special expertise. Accordingly, the ACLU of Georgia opposes HB 1274. Our primary concern is that this bill prohibits constitutionally protected speech and especially risks punishing criticism of the government of Israel. The line between criticism of Israel and discriminatory animus is too blurred to function as a law that could ultimately use to punish people for their speech. The IHRA's definition states that criticism of Israel, similar to that level against any other country, cannot be regarded as anti-Semitic. This language is unclear and unenforceable. The state of Georgia is not a Ministry of Information that decides whether certain criticism of Israel is similar to that leveled against any other country. For example, as a Jewish American who is frequently critical of recent Israeli administrations, I wonder whether my speech could be construed to run afoul of these restrictions. Or more likely, would a non-Jewish person making the exact same criticisms as me be considered anti-Semitic while I am not? That is the determination we are leaving to the state of Georgia to make, and that is problematic. This definition remains useful as a moral or sociological definition, but not as a legal one. Even the Office of the United Nations High Commissioner for Human Rights, the OHCHR, which has adopted the IHRA's definition as a working definition, has clearly stated that this definition is a non-legally binding definition intended to guide and educate. It is not a means to squelch debate or free speech, and those who misuse it this way should be opposed. Mr. Chairman, I also wanted to add a point of clarity regarding the bill sponsor, Representative Carson's comments earlier. He talked a bit about the adoption of this definition internationally. I just want to clarify there's a difference between being codified into law and being used just as a working definition to guide and illustrate. And I think in most of those examples you'll find it is the latter. And you know, in the way that IHRA's definition is referenced in this bill is also statutorily problematic. In a way, a sort of backdoor engrossment, meaning that the operative text, the IHRA's definition, is not spelled out in the law, but rather must be referred from a source outside the Georgia Code to understand what the definition of anti-Semitism is. This has several real consequences in how courts interpret the law. For instance, what if a court rules that part of the IHRA's definition is unconstitutional, but can't sever the problematic text from the code because it's not in the code? You know, the core matter here is that HB 1274 is an unnecessary piece of legislation because Jewish Georgians are already protected by the Georgia Code and the Civil Rights Act of 1964, under which numerous courts have held that Jews, whether actively religious or not, are protected from discrimination under the race and national origin language. The bill drafters have yet to identify a single blind spot in Georgia law where Jewish Georgians are not already provided the full protection of anti-discrimination and hate crime laws. It was suggested that prosecutors are choosing not to go forward with hate crimes in cases involving Jewish Georgians. Again, we have seen no evidence that this is the case. HB 1274 directs the government to consider anti-Semitism as evidence of discriminatory intent for any law or policy that provides for enhanced criminal penalties. However, under HB 1274, if a defendant's speech fits a controversial definition of anti-Semitism, such as legitimate criticism of Israel, the defendant's constitutionally protected speech could be improperly construed as discriminatory intent. Because crimes with serious penalties are involved, we must be cautious about the potential consequences. Ultimately, HB 1274 would have a chilling effect on constitutionally protected political speech. This committee should not pass legislation as drafted because it's unnecessary, and at the very least, this committee must reconsider incorporating the IHRA's definition of anti-Semitism in Georgia law. Mr. Chairman, we are happy to work with the bill sponsors and organizations interested to address the issues that have been raised today. If you'd entertain a motion to table this bill, that'd be great. You know, it's pre-crossover. There's still lots of time to work out the details. Thank you so much.
One question I have, when you talk about criminal penalties, unless I'm missing something, are there any other criminal provisions we have outside of our hate crimes law where this would come into effect?
You know, that's a good question. It's hard to know the exact application of this because there are so many places that this could reference in the code, but I'd be happy to get back to you with a more specific question to that.
Okay, because my memory of the hate crimes law is under Georgia law, you have to be convicted of an underlying offense, and then a jury in a separate trial will determine whether or not someone selected their victim, as the language is here, based on their race, color, religion, or national origin. If that's the only one, then I think the way I'd see it playing out, you can get back to me on this, would be basically a jury charge if you had somebody that was accused of discriminating against somebody because they were Jewish that would give reference to this definition, I'm assuming. And that would be something that could be used at looking at their intent. Is that your understanding of it as well?
For that, I'd have to get back to you regarding a specific question. But let me just also state that, you know, this bill is not just about hate crimes context. You know, it also has to do with anti-discrimination laws. It has a large potential impact. So I think we need to be considering, you know, all the potential implications of HB 1274.
I already have some questions in the committee. Mm-hmm. Senator Jones?
Thank you, Mr. Chair. So it seems like, because with the anti-Semitism, you're talking about racism and religious, also discrimination. But you're kind of pulling it out and saying this is a specific kind of racism or religious discrimination. Do we have anywhere else in the law where we kind of pull out and say this is anti-black racism specifically, this is anti-Hispanic racism specifically? That, if you understand what I'm saying there.
I do. Yeah, I am not aware of any other situation in law we have that. I mean, my understanding is that protections for race, religion, skin color, national origin, those are sufficiently covered by the Georgia Code, by the Civil Rights Act. It is definitely unique to go in and do this. I mean, I guess one question we were thinking through is if you were to adopt a definition for Islamophobia, is there an agreed upon definition for that? How would you codify in the code for anti-blackness? So thinking that through how that would be is interesting, but it's potentially problematic.
Senator Rhett.
Thank you, Mr. Chairman. I was wondering if both sides would be reconciled to perhaps work together on the language before we take a vote and see if we can come up with a suitable solution to the differences.
As a committee, I think we will take this bill up in another hearing for a vote. So there will be time to do that. I'm not sure. This bill's gone to the House already. There has been some changes. I'm not sure if there's some language that your group would propose to add to it that would give you more comfort or not. That's something to think about, though.
Well, we definitely love to be involved in that process and provide any useful suggestions that can make this bill better.
All right, we have Senator Cowsert.
Thank you, Mr. Chairman. You were talking a little bit faster than I can comprehend there at first, but you said something that in the bill that criticism of this would in no way prevent political discussion or freedom of speech. Is there a clause that says that? If so, isn't this argument kind of moot?
Well, for sure, Senator. Not sure I mentioned it specifically in my testimony, but it was mentioned earlier during this hearing about I think it was lines 50 to 53, saying that nothing in this code section shall be construed to diminish or infringe upon any right protected under the First Amendment. And I did want to address that because the question is, can the Georgia legislature pass anything that violates the Constitution and the First Amendment? And the answer is it cannot. And merely reciting that an unobjectable fact has no operative value. So from our perspective, that line gives away the fact that the bill trods on dangerous territory with regards to free speech.
Okay.
So we do have legitimate and serious.
But doesn't that kind of make it clear, though, that it doesn't infringe on your free speech? I mean, the thing, Israel is unique. It is a Jewish state. And so you're wrapping nationality, ethnicity, and your religion all into one there in Israel, and it's recognized that way worldwide. So I can see where somebody that's very anti-Israel is almost implicitly anti-Semitic. And the way I read this is it's just saying that can be considered by a finder of fact in determining whether you had discriminatory intent. If you're out saying death to Israel or whatever, isn't that implicitly anti-Semitic or against the Jewish religion and nation, which it's a nation state? I mean, it's such a ball of wax. I'm just wondering. I wondered if that lines 50 to 54 doesn't make it clear that you can be critical of political policies of that state, and this doesn't hurt you on doing that, but it also could be evidence that you hate Jewish people.
Well, unfortunately, that section is superfluous. If you wanted to make sure the bill doesn't run afoul of the First Amendment, the operative section of the text should be rewritten or altered. And I will say that the way you described, it gets to the point of the matter, whether being critical of Israel or kind of whether that is anti-Semitic or not. We're having the state of Georgia make that determination whether someone's speech is anti-Semitic. And say if I made that speech, I'm critical of the Naftali Bennett administration, I kind of doubt that people would consider that to be anti-Semitic, but maybe someone else making that statement would be. So is it really our position to have the state of Georgia, be essentially Ministry of Information for policing people's speech here?
Okay, thank you.
Thank you so much.
Any other questions from the committee? All right, thank you. I want to ask the two representatives to come back up. We are going to hold on taking a vote just because we have the extra luxury of time right now, and try to get you guys back on for another hearing soon. One thing I would like to know, my simple reading of the bill looks to me like we have the hate crimes law where you have to commit an underlying offense where you're targeting somebody. I get how it comes into play there, if I'm right, but then when you look at other ways departments and agencies would use this, it looks like you still have to have somebody that has done something against somebody to discriminate against them, and this will be evidence of discrimination. I guess the question would be for everybody that testified is, where do you see this coming in at the end of the day? And I personally, I think there's some desire to have a uniform definition in the code, but those are just my thoughts. I'll let you close it out.
Yeah. Well, I think the biggest issue we've had, both in publications and people knowledgeable of this bill, is people, unfortunately, being lawyers, reading the bill and understanding the implication is exactly what you're saying and why this is, let's just focus on this. Does this bill talk about speech at all? No. Here's why. Lines 44 to 45. It says all State Department's agencies shall consider anti-Semitism as evidence of discriminatory intent for any law or policy in this state. So first step, we have a law or policy in the state. Is that law or policy constitutional and limiting speech? That's the first test. Well, we know that answer is no, because that would not be on the books. And then the next step is this code section here that we are using. And why are we defining anti-Semitism, Senator? Is because Judaism is different than xenophobia, racism, hate against LGBTQ. Your eyes got big. Why? Because Judaism is a national origin, it's a race and religion. So you have situations where a person could firebomb a synagogue, and they could say, you know what? That was my speech against Israel, because I don't like Israel. And we've had judges in other countries hear that argument. And that's why this is so important, because when does actions, conduct, get to the point of anti-Semitism? Well, why do we have laws on the books? We have laws on the books so juries and judges can make that understanding. And that's why this bill is so important, is because we are giving guardrails around it. This in no way limits any speech against Israel. In no way limits teachings about Israel. No, I could sit here right now, 2 years from now, this bill is being passed, and yell out, Israel is a racist nation. Israel is horrible. The government Israel kills people. The government Israel is the worst thing I've ever heard, and they are just treating people horribly. You can say all of that for two reasons. One, because this bill in no way limits speech, because once again, it is, as I said before, that Supreme Court case. You are allowed to use it as evidence of discriminatory intent, but also in the examples, it says you can talk about Israel as you would every other country. Well, we know there's plenty of people out there through both presidencies who are saying U.S. is racist. We know that. So, first of all, for two reasons. The main thing is this does not limit speech in any way. Second of all, you can talk out about Israel as much as you want, and it doesn't chill speech, because it's not about speech. You can critique the government. And the reason we don't have a situation in Georgia where we've seen a hate crime against anti-Semitism, do you know how many cases in Georgia we have had where it has an added sentence proposed by a prosecutor for hate crime and anti-Semitism? 0. Ask the prosecutors in the hallway. You know why? Because Judaism is complex, and there are so many different definitions between national origin, racism, or national race or religion. It makes it complicated. So what are we doing here? We are giving specific examples, guardrails of saying when you have a policy already in place, what is the evidence we're going to use to show intent? That is not speech. That's why this is different. And unfortunately, we have groups who have stances throughout the nation for different reasons based on different laws, and those groups have national stances, and they're not going to change from those. But when you read this law, there's nothing to do with speech, helps us understand anti-Semitism, lets people talk about Israel as what they want, is not calling out Israel, but is saying, you know what? When you start talking about Israel and saying, you know, the Jews are doing that, well, that is not talking about Israel. That is saying the Jews are being bad. The Jews are doing something. That's when we reach the level of anti-Semitism. You know who's going to decide that? A judge or jury based on the guardrails we're pointing on this, and that's why that's so important.
I already have a question from Senator Hatchett.
Thank you, Mr. Chairman. And this is just discussion. I support this policy and your intent here. I guess just going back to the intent that you were talking about, is your intent of this legislation to penalize anti-Semitism? And if so, I guess my question is, we have the hate crimes bill, which is in Title 17, and this is trying to define anti-Semitism in Title 50. And I'm just wondering why you went with Title 50, which goes beyond like criminal statutes, and why not try to do this in Title 17 instead?
Yeah, it's a great question. Thank you, Senator. So what we're trying to do is define anti-Semitism in Georgia, and how this, when we define it, it's going to be applied to policies and laws that are already in place throughout the Georgia Code. So it doesn't matter where the definition exists in the code, it's throughout the definition. And so when we have a policy or a law in the state that has evidence of discriminatory intent that includes national origin, race, or religion, then this comes into play. And it's based on the conduct that occurred. So that's why it takes it out of speech. So pretty much we're saying when you commit a conduct and then there's another policy that talks about that conduct, and what is the evidence to show that that conduct was anti-Semitic? Well, that's when we start looking at these examples. You know what? A defendant one day is going to be in court and go, you know what? I wasn't accusing Jews of being people, so this can't be anti-Semitism. They're going to use this to defend themselves one day in court. And so these examples are perfect examples of holding Jews collectively responsible for actions of the state of Israel. Everybody in this room would agree that's anti-Semitism. I hope they're shaking their heads behind me. Applying double standards by requiring of its behavior not expected or demanded of any other democratic nation. Applying double standards by requiring its behavior. Well, that's saying that Israel should do certain things, right? But here's the difference, though. Anybody in this room, or anybody, all the Jewish people or non-Jewish people, can get up in a classroom, can get up on a pedestal and yell that all they want, because that is not being criminalized in our state. The only thing that's being applied here is that when there's a law and policy already in the book, which goes back to your question, how are we finding evidence of conduct to see? So a person firebombs a synagogue or punches a Jewish person in the face.
Your colleague needs to go to another hearing.
I apologize. I'm going to leave it with my more passionate representative. I feel very strongly about this. It does not limit free speech. I do apologize to the committee. I've got a whole retirement committee waiting on me to move a Senate bill, if that's okay.
Please move a couple, I guess.
Yes, sir. Thank you for the committee's time. Thank you.
Thank you.
Yeah, thanks, Mike.
So going back to your question, the reason we are doing that is this is just referring back to any law or policy, and when the conduct is applied, how do we figure out if that conduct is anti-Semitic? Well, we can look at other things they've done, including the speech, to then look at these examples. However, the speech is not being criminalized, and based on that Supreme Court case, that's why this is constitutional. Did that answer your question?
Yes, it did. Thank you.
All right, one other question for the committee. Senator Jones?
It's more of a comment. Number one, I would say that we it's problematic when we start trying to compare about oppression and things of that nature. That becomes problematic when we lose each other there. But number two, the definition itself, anti-Semitism is a certain perception of Jews, go down. That may be okay. It's the examples that are still giving me a problem. Because what will happen in a court case, I would imagine, is that to prove racism with hate crimes, the court or the prosecutor is going to give whatever examples they believe proves their case. Same thing I could do with African American. That's why I was saying, could we pull this out for anti-black racism? We could list out examples, and that to me starts a problematic situation, to where now we're going to say, okay, this is anti-black racism. And the example is, if you talk about black fathers not being at home and that contributes to the deterioration of black family, that's anti-black racism. If you talk about hip hop, that's anti-black racism. And then we can say, and I don't know, anti-Hispanic, and these are the examples. Those things will come out within the evidentiary scheme work when a case is being done. And then it's up for the jury to make that determination. To me, and I'm African American, obviously, so to me, even though I can see where we could say, hey, we want to develop our own definition of anti-black racism, and these are our examples, it still would trouble me. And I think that's where we could be headed, and that to me becomes troubling, because I don't think it's going to stop. It's kind of like pornography, race. We see it, we know it when we see it. Why give these examples? Because we could do this with any other group. Yeah. Who also has been just as oppressed. So I don't think we want to go down that road, but just that to me just becomes problematic when we start saying these specific examples then prove a case, so to speak.
Yeah.
That's where I am.
And I hear you, Senator, and I think you said it best. You said you know it when you see it. Unfortunately, with Judaism and anti-Semitism, you don't know it when you see it. That's the problem we're having on college campuses, we're having throughout our state, throughout our country. And that's why having examples, once again, it is not simple because it is national origin, race, and religion. So unfortunately, it is not a comparison any way of the past and I forgot the word, but this has nothing to do with who has been harmed more in their history of genocides or however you want to. This has nothing to do about that. This is why is Judaism so complex. It's complex because it's not just a race. It's not just a religion. It's not just a national origin. As you say right now to a friend anywhere, what is anti-Semitism? That's not easy. That's not easy. So you don't know it when you see it. That's the problem we're having. That's why we're giving specific examples that can be used to prosecute, but they can also be used as a defense. And that's why it's so important, because right now there is 100% no law in the book that discusses anti-Semitism. So a prosecutor can literally say anything is anti-Semitism. That's my concern right now. So it can be used against people in a hate crime situation. They can go on a Facebook page and pick anything out to say, you know what, that should be an added sentence because that was anti-Semitism, and they have no defense. They have no way to defend it. Because anti-Semitism, so this is why these examples are so important. Why we're using these examples is because it's being used internationally. And just so there's a confusion about the authors, you can read all about this. There were about 6 authors on this. One author took credit, the other author said they didn't, and one author said it should be used to learning, other authors disagree. That whole thing is a mix-up and anybody can say want. But what's key here is we're not talking about freedom of speech. We are giving a standard to be used to applied laws, and you know, it's hard because it gets very personal. You know, when you have a history, different histories that we share, and you try to apply what you know about yours to something else, but it's just not the same because it's not just a race. You know, we even heard recently somebody famous say it's not a race. And so that's what makes it and why it's so important. And I can assure you, we can produce the 6-page list of groups who are for this internationally, Jewish groups. We didn't think it was necessary because I don't like playing that game of which Jews are more for it and more not. That's not. We have to look at the laws and how it's being applied. And last thing I'll say is just repeat it. If you talk to anybody about the legal application, it doesn't limit speech, and I can show you the Supreme Court case that specifically says that when you're showing intent of conduct, that in no way is limiting speech in any way, and anybody can say anything they want about Israel, who they are, anything. Actually, they could even say anything after this bill anti-Semitic, and there will be no law on the books that criminalizes them, because this doesn't do that. This is applications to the conduct of hate crimes, and many there are others. I think that was a stalling tactic, but okay. Motion to vote.
Fortunately and unfortunately, not on the committee. Well, thank you for presenting the bill and the passion that you have. I would encourage you and everyone that spoke on the bill to talk to other committee members about your issues with the bill and your support of the bill. If you want to send us anything else in writing, we try to always print things for the committee to have in their folders. We also can email that out to the committee if you have more thoughts on this. You had some good questions that were asked about the application of this too, and so it might be good to get some more information from everybody on those things. And with that, we are adjourned.
Thank you.
Thank
For your time, Chair. Thank you.